Hello, and welcome to our Accelerate workshop for businesses looking to expand into the UK. I'm Tamara Ecker, Managing Director for British American Business and President of the British American Business Network. For those of you not familiar with British American Business, we are the leading trade association exclusively supporting businesses with operations in both the US and the UK markets. And BAB Accelerate is our targeted business networking community, offering insights and connections for middle market companies, growth businesses, and startups looking to establish a transatlantic footprint. This series of virtual on-demand workshop sessions will offer you insights across a variety of areas critical to setting up businesses in the UK, including tax planning and VAT, talent management and acquisition, and legal considerations for doing business in the UK. We will also run through a quick speed round summary of immigration considerations. Lastly, a very big thanks to JetBlue for helping make this series possible.
Hi, everyone. My name is Simon Walsh, and I am a partner at Oury Solicitors. I head our corporate and commercial team, and on behalf of British American Business, I'd like to welcome you to this session titled Legal Considerations of Doing Business in the UK. I am going to spend the next 40 minutes or so just talking to you about some of the key areas that clients that we work with, i.e. American companies considering or already having moved to the UK, considering the sorts of issues that they come across in the early stages of their plans to move into the UK market. So in particular, the agenda for today is going to be very simple. It is just I'm going to do an introduction. I'm going to talk a little bit about forming an entity in the UK and the legal forms of entities that we have in the UK. I'm then going to talk a little bit about UK employment law. I'll then look at some matters in relation to intellectual property. And then finally, I'll look at some matters in relation to data privacy. And at the very end, there was to be an interactive Q&A session. So what I've done is I've just posed 4 questions, which are sort of the common sorts of questions that we get asked about people when they're considering moving to the UK. So what we're going to be talking about today, after my little introduction in relation to the UK, is we're going to talk about entity formation, i.e. the legal entities that are most commonly used as a means of setting up a company in the UK. I'm going to talk about employment law. I'm going to do a little bit on intellectual property. I'm going to talk about data privacy. And then at the end of the session, we were going to have an interactive Q&A. It'll be very, very one way for the purposes of this presentation. But what I've done is I have posed a couple of questions that we commonly get asked when we're talking to American firms about moving into the UK. So let's start by just looking at the UK as a country. It's important, and a lot of foreigners, not just Americans, but Australians, Kiwis, whoever, they often overlook the fact that the United Kingdom is in fact 4 separate countries. The United Kingdom is made up of England, Wales, Scotland, and Northern Ireland. And this poses an interesting perspective from a legal point of view. And it's a little known fact that the territories or the devolved administrations of both Scotland and Northern Ireland in some cases have their own laws. So most all lawyers, including myself, who are qualified in England, are qualified to practice in England and Wales. And in Scotland, there will be lawyers that are qualified to practice in Scotland, and in Northern Ireland, there will be lawyers qualified to practice in Northern Ireland. Now, it's fair to say that there are some very, very subtle differences in most things, and most things that we deal with on a daily basis are overarching, i.e. they apply to the whole of the United Kingdom. But it's important to note that there are some nuances, for example, in employment law, where there are differences between employment laws in Scotland and employment laws in England, and similarly, employment laws in Northern Ireland as well. And as a result of that, if we are ever working with clients and they're looking at employing people within Scotland or in Northern Ireland, then we will always work with one of our partners in those territories that are more specialised and are better positioned to provide advice in relation to those nuances. And for example, and these are just some common examples, Scotland actually gets slightly more public holidays than we do in England, in fact, by one more day. And I'll talk a little bit about that when we come to the section on employment law. And for example, in Wales, they have slightly different tax rates when it comes to taxing employees. I mean, ultimately, the end tax that an employee pays is the same, but it's structured slightly differently if you compare, for example, England and Wales. So key point here is whilst doing business in the United Kingdom is very, very simple and easy, never overlook the fact that sometimes you might, depending on where your customers are located and depending on where your staff are located, you may have to navigate slightly different laws across different countries within the United Kingdom. And certainly one thing that's always very, very handy to know is that the United Kingdom, every country in the United Kingdom, in addition to having a different name, they have different languages. So Wales, Northern Ireland, clearly everyone speaks English, but their sort of traditions are slightly different. And they are truly born out in culture, which you will discover in good time as you move around the UK. So having said that, most everything that I say to you in this presentation will apply across all of those 4 countries. And where there are some differences, for example, when we come to talk about employment law, I will highlight just some of the very, very high-level differences of things that you might come across. The good thing, certainly for me as a corporate and commercial lawyer, is on the whole, the main piece of legislation that we work with is the Companies Act 2006, and other than some very, very unusual situations, it pretty much applies across all of the United Kingdom, which is a nice little segue into the first main part of my presentation, which is on entity and formation. And what we're talking about when we refer to entity and formation is the different types of legal structures that we have here in the UK that people or companies will make a decision about when they want to set up an entity in the UK. So there are 3 main structures that we come across here. The first is a limited company, and that is the most common. I'll talk a little bit more in a bit more detail about that in a moment. The second is the registration of an overseas entity, so effectively a branch office of the foreign company. So in the case of everyone on this presentation, it would be a branch office of a US parent company. And of course, we also have limited liability partnerships and a couple of other less common structures here in the UK, which I'm not going to talk about just at this point in time. So let's just focus on limited companies then. A limited company is a company that is limited by shares. And what that means is that to some extent, unless the directors are acting fraudulently, the liability of the directors is, as suggested by the name, is limited. A limited company is the most common form of company here in the UK. We do have companies limited by guarantee, as well as some charitable organisations and those types of things. But for the purposes of the presentation today, I'm pretty much going to focus on limited companies. Unlike other countries in this part of the world, limited companies are very, very quick and easy to set up. So on the whole, you can set up a limited company in the UK in 48 hours. Pre-COVID, it used to be much quicker than that, but for a whole bunch of reasons, it takes slightly longer at the moment. But it's certainly, the United Kingdom is certainly one of the quickest and easiest places to set up a company. It's important to understand that there is no requirement for any minimum paid up capital here in the UK. So it is very common for a company to be incorporated with a handful of shares of nominal or what you would possibly know as par value. So unlike some of our European counterparts, where there are sort of minimum capital requirements running in the 20s or 30s or 50,000 type mark, in the UK, there is no requirement for any minimum paid up capital. And interestingly, there is no requirement for a local resident director. So you can incorporate a company here with one share of £1 with a non-resident director. And it's not uncommon actually for that to happen. Now, in a lot of cases where our American clients are incorporating companies in the UK, they will be incorporating their UK company as a wholly owned subsidiary of their US company. And that process is no different to it's the same process whether you're incorporating a company as a wholly owned subsidiary or whether you're incorporating the company as a standalone company with its own shareholders. One of the requirements in the UK is that when you incorporate a company, not only do you have to have at least one director, but you also need to have a registered office here in the UK. And to a lot of people's surprise, the authorities such as our taxing authorities and also our registrar of companies, they like to send businesses things by traditional post. So a registered office is extremely important. It's also important to understand as well that most information about a limited company, and in fact, most other companies as well, is available on the public record. So for example, at the registrar of companies, you will find when your company is registered, you'll find its company name, you'll find its company number, and you'll also find information about who the directors are and a couple of other things that I will talk about a little bit further down the track. A lot of our clients will ask us, once they've been through the incorporation process, what the annual reporting requirements are in relation to a company, a limited company that is. And there are two key dates, or there are two key reporting obligations. The first is that on an annual basis, you are required to file accounts of your UK company with the registrar of companies. So those accounts will need to be prepared by an accountant. You may or may not need an audit, and I can talk about that in a moment. But at least on an annual basis, you need to file your accounts. Now, when you incorporate your company in the UK, the annual filing date is automatically set, but you can change that. So for example, if you're incorporating a wholly owned subsidiary of a US company, then it would make a lot of sense for you to have your accounts filing date as the 31st of December, because that, of course, is the year end in the US. So even though you might be allocated some, it's not completely arbitrary, but a date that may not necessarily coincide with 31 December, after incorporation, it's very, very easy to change it. So mandatory to file annual accounts once a year. And we also have a requirement to file what is known as a confirmation statement. That confirmation statement is due on a different date to your annual accounts, but the confirmation statement is just the directors of the company making a statement to the registrar of companies here about who the shareholders are and who the officers of the company are. So that, once again, that confirmation statement is due to be filed on an annual basis. Just a word of warning, there are penalties for not filing by your deadline. So important to always keep that in mind. Slightly unusual thing here in the UK when you have a limited company is that we also, or our registrar of companies also maintains what is known as a PSC, or Persons with Significant Control Register. And essentially the PSC register is designed to alert people because it's available on the public record, but the registrar of companies as well, it alerts them as to who the individuals are that control a company. So often in the US, you will talk about alternate beneficial ownership. The rules are slightly complicated in relation to the PSC register, but essentially the secret or the key is within the name, and it is a register of people that control the company. For the purposes of today's presentation, we won't go into too much detail on that, but just bearing in mind that that there is it is a requirement that the PSC register is always kept up to date. Often what happens is when you incorporate a company, you might incorporate it as in the name of one individual, and if that individual, that person will be listed on the PSC register, but over time you might raise money, and that person may no longer control the company after a couple of investment rounds. It's always important to remember to keep an eye on the PSC register. So limited companies, as I said at the beginning, are the most common form of company you find here in the UK. And just in summary, they can be either used for the purposes of setting up a wholly owned subsidiary of a US company, or they can also be used for the purpose of setting up a standalone company. Some of the other most common form of a legal entity in the UK is the branch office of an overseas company. And we're often asked, particularly by people who have an established business abroad, when they come into the UK, whether they should register a limited company or whether they should register a foreign branch. On the whole, we encourage people to register a limited company rather than a branch office, for the simple reason that even if in your home territory, you have no requirement to file your accounts annually on public record, if you're set up as a branch in the UK, you will have that requirement to file your parent company accounts here in the UK. And that is normally one of the primary reasons why people rarely set up branch offices here in the UK. They do exist. They're quite common in certain sectors. So, for example, a lot of universities will have branches here in the UK, particularly if they're doing student recruitment. And some companies who are raising money in the UK, or perhaps who are looking at listing in the UK on the main LSE exchange or any of the alternative exchanges, there may be some benefit in actually registering a branch here as well. Even though a branch has its own legal entity, and details of the branch appear on public record in exactly the same way as a limited company do, but you do have some slightly different filing requirements that you may not have in your home territory. And one other important point to make is it takes slightly longer to set up a branch in the UK, but that's primarily because you have to provide much more information in relation to the actual activities of the company outside of the UK for whom you're setting up a branch. And then finally, limited liability partnerships. They are more common in the professional services sector here, although we are seeing more and more LLPs set up as parts of joint ventures or whatever it might be. So always important to remember that sort of a limited liability partnership, which is a true partnership, but the liability of members is limited. They can have their purpose, and there are some situations where we do actually recommend to clients that they set up an LLP. Just before we move off entity information and look at matters in relation to talent and employing people here in the UK, One important point to remember about audits in the UK is that even though when our taxing authorities determine whether your UK company requires an audit, they actually look at the group size and not just the size of the UK company to determine whether an audit is required. Now, if the group, i.e. the UK entity, its foreign parent, and any other global companies in the group, if collectively that group breaches what we call the audit thresholds here, then the UK entity, and only the UK entity, is required to have an audit in the UK. And just to sort of give you, just to put some of that in perspective, there are 3 thresholds that we look at when we come to determine whether you need an audit or not. And those thresholds are turnover, if it exceeds 10.2 million, the gross assets, if they exceed 5.1 million, and number of employees, if you have 50 or more. So you only need to breach 2 of those 3 thresholds on a global basis to require by law an audit of your UK company. But always, we're often asked questions about audit and what the audit requirements are. So just remember that there are thresholds that we look at the group, or our taxing authorities look at the group, and if the group exceeds 2 of those 3 thresholds based on turnover, gross assets, and number of employees, then the UK entity, and only the UK entity, would be ignored. Okay, so now we're going to look at employment law, and in particular, I'll highlight some of the differences between employing people in the UK and employing people in the US. The UK is no different to any other country at the moment, and that is that there is an incredible war on talent. So, you know, pre-COVID, when sort of unemployment rates were sort of running slightly higher than they are, and certainly when we were part of the European Union, there were ready pools of talent, and it was reasonably easy to recruit people across a whole breadth of sectors and skill types. That is becoming harder and harder, simply because there are there are fewer people. Our immigration laws are such that it's slightly more complicated to bring talent into the UK. I won't go into immigration in this presentation, but I do believe that one of another partner of British American business will cover off some of the key points about immigration. But needless to say, as a result of that, the war on talent is just as fierce here as it is everywhere. But that's not to say that you can't recruit and find the right people for your organisation as you make your plans to set up in the UK. A couple of points I want to make, and a lot of Americans in particular are quite surprised by this, but in the UK, we don't have this concept of at-will employment. Essentially, by law, before somebody starts working for you in the UK, you are required to give them a written contract of employment. And within that contract of employment, there will be a statutory or above statutory notice period. And as an employer, you are required to observe the notice period in an employment contract, because it is just that. It is a contract of employment. If you were to terminate somebody without following the requisite notice period in the contract, then you as the employer would be in breach of contract. Very, very important point to remember in relation to employing people here in the UK is that whilst we don't have this concept of at-will employment, at the moment, an employee only earns a right not to be unfairly dismissed after they've had 2 years of continuous employment or more. So what that means is within the first 2 years of employment, if you decided that somebody was not performing then you are able to bring their employment contract to an end, so long as you meet your contractual obligations under that contract. So, for example, if somebody had worked for you for 12 months and they were not performing and their contract of employment said they were entitled to 4 weeks' notice, then you could terminate that contract without giving them too many reasons, so long as you either paid them for their 4-week, paid out their 4-week notice period, and any other rights that have accumulated under that contract until their point of termination, or you could make them work their notice period, which in the example I've given would be 4 weeks. So even though we don't have this concept of at-will employment, don't be too concerned, because you do have the right to terminate people if they're not performing, but it becomes more complex after an individual has 2 or more years of continuous service. But within that first 24 months of service, it's reasonably straightforward. Now, when I say that after 2 years, an employee earns the right not to be unfairly dismissed, that doesn't mean that you can't still dismiss for poor performance after somebody has been working for you for 2 or more years. All it means is that there is a process that you have to go through in order for you as the employer to ensure that the departing employee is not able to bring an unfair dismissal claim against you. So I don't want to sound negative, but for a lot of our customers, so new people moving into the UK, they get quite concerned about this, but the important thing to remember is in the first 2 years, it's reasonably easy if things are not working out to move someone on. It just becomes more complicated after a 2-year period. As you can see from the slides there, and I've already made this statement, before somebody starts working for you, you are required to give them a written contract of employment, and there are certain things that must go in that contract of employment, and I won't go into too much detail, but it will have things like what the job title is, what the annual salary is, what the annual leave is, what an employee needs to do if they have a grievance against the company or if they're to be disciplined. So there are certain mandatory things that need to go in that contract of employment, but the key to remember is that technically the individual, as the employer, you must give an individual an employment contract before they start employment and with you, and you should get them to sign it as well. Another point that we often get asked about, particularly by Americans, is about statutory annual leave or vacation days here in the UK. And a lot of Americans are very, very surprised to learn that the minimum number of statutory holidays is 28 days here in the UK. Now, how that's made up, that is made up of 20 vacation days and 8 public holidays. So all in all, a minimum of 28 days. Now, I say a minimum because it's very common to find employers, particularly in this very, very competitive recruitment market, offering employees 33 days. So 25 vacation days and 8 bank holidays. Now, for a lot of Americans, that comes as a huge surprise, and that generally applies to all levels of an organization. So the minimum statutory requirement that you must give your employees is 28 days. Now, often in the employment contract, those 28 days, we don't make a distinction between vacation days and bank holidays or public holidays. Often you'll see the statement, it'll be your annual leave comprises 28 days, including the 8 statutory bank holidays. And that's simply because we don't have the concept by law here of payment for working on public holidays. So, for example, if your employees were required to work on a Monday that was a public holiday, you would just pay them their standard rate of salary. You don't have to pay them time and a half or double time or whatever it might be. Now, that rule varies across different jurisdictions, but in the UK, even if an employee works on a bank holiday, you are not required by law to pay them any loading for that bank holiday. That's not to say that some employers don't, but by law, you're not required to. A couple of other things that that we like to talk to Americans about is this concept of maternity leave or shared parental leave. Maternity leave for a lot of our American clients is, a lot of people are very surprised that it is actually 52 weeks. So a family or a kind of a mother or an adoptive parent is able to take 52 weeks out of employment for the purpose of looking after their newborn or their newly adopted child. Off the top of my head, and I'm not expecting you to remember this, is that by law, the first 6 weeks or the first 2 weeks of that 52-week period, that individual is not able to work at all by law. So something that's always worth remembering. The way that that maternity leave is, or the way that people get paid when they're on maternity leave, is the first 6 weeks of maternity leave is paid at 90% of the individual's salary. And then there is a requirement to pay a lower amount on the balancing. So there is statutory maternity leave beyond that. Now that often comes surprise to our American counterparts, although it's becoming increasingly more common in the US to offer maternity leave. The reason why on the slide it says maternity/shared parental leave is that we have this concept in the UK that the partner of somebody who has either given birth to a child or adopted a child is actually able to share maternity leave. So it's something that would typically be covered off in an employee or an employment-related policy, but just worth bearing in mind that we have this concept here that paid maternity leave for 52 weeks. It's not all paid, it's 6 weeks. I think it's then 33 and then it goes to statutory. But there is the, we do look after people when they're not working as a result of bringing kids into the world or adopting kids as well. One of the questions we're often asked is about pensions and employee benefits. Now, by law here in the UK, the moment you have somebody who starts working for you, you are required to contribute to what is known as an auto-enrollment or statutory pension. And essentially what that means is that as an employer, you're required to set up what is known as an auto-enrollment pension scheme. And you must automatically opt all of your employees into that scheme from the beginning. Now, an employee can choose not to, well, an employee can choose to opt out of that scheme, but as an employer, you can't offer any inducements to have the employee opt out of that scheme. Put it all into perspective, the statutory pension contributions are 8% of either qualifying earnings or the individual's wage. There are some reasons why you may choose one over the other and why it might be different, but I won't go into those details for the purposes of this presentation. But key thing to remember is that the minimum statutory contribution is 8%. 5% of that is covered by the employee, and 3% of that is covered by the employer. So the minimum amount that an employer has to contribute to an employee's pension is 3% of, let's say, qualified earnings. It's quite interesting. So one point I should make, it doesn't cost a lot of money to set up these schemes. There are some very, very standard schemes that most employers will set up under. So I wouldn't be, if you're concerned about mounting employment costs or the cost of employment here, people here, I wouldn't be too concerned about it because they're not that expensive to set up or run. We were having a look at some statistics earlier today, and whilst the minimum statutory contribution is 8%, if you look, you can pay more than that. So the employer can pay more than the statutory 3%, and an employee can contribute more than their 5%. We were looking this morning, and on average across all UK businesses, it looks like the average contribution is sitting at around about 11%. And but we can provide more information about that as and when required. We're often asked about other benefits. So our US customers in particular will say, look, we're looking at setting up here in the UK. We understand that, we've got to pay salaries and kind of cover vacation time and all of that. What are some of the other benefits? Well, probably the most common benefit is health insurance, health and or dental insurance. Now, you may or may not be aware, but the UK has everyone who is legally entitled to live and work in the UK has access to the National Health Service, which is free at the point of delivery. But the National Health Service, it's fair to say, is doing an incredible job, but they are very, very stretched. So often it can take you a couple of weeks to get an appointment to see an NHS GP. And as a result of that, or a general practitioner, medical doctor, MD, as a result of that, what we're finding is that more and more employers are offering their employees private medical insurance. Now, for an American, that might sound like, the alarm bells might be going off, but health insurance for employees in the UK is surprisingly inexpensive. And the reason for that is that they tend to look at the sort of average age of kind of an employee group, and clearly they kind of amortize the cost of all of your employees, on the understanding that kind of younger employees tend not to claim as much as older employees. So when you hear, or if you're sort of putting together a budget and you're looking at what you might want to do to offer your UK employees something that is certainly in keeping with market trends, I wouldn't discount looking at health insurance and or dental insurance as well. And then one of the other benefits that you often see, or we're seeing more and more, slightly macabre, but death in service benefits and loss of income benefits as well. There's a lot of information available online about different types of employee benefits, but certainly a pension is mandatory by law. More and more of our American clients in particular offering their UK employees private health insurance and dental insurance, and also looking at death in service and loss of income. So, for example, if somebody suffered a horrific accident and was incapacitated and were unable to work. There's two other points I wanted to cover off here on employment. One is employment-related taxes. So we're often asked about employment-related taxes. The first point I want to make is that we don't have payroll tax here in the UK. There is this concept, certainly in some jurisdictions, where there is a tax levied by the government on the actual size of your payroll. That doesn't exist here. The most common way of taxing people is PAYE, so pay as you earn. And everyone who is employed in the UK has an obligation to pay PAYE. It's tax deducted at source, and your payroll bureau, so whoever processes your payroll here in the UK, they will be doing the PAYE calculations for you. An often unknown fact here in the UK is that unless you're a high earner here, so unless you earn more than £100,000 per annum, you don't have an obligation to complete a tax return. So anyone who earns less than £100,000 a year, and that's from all sources of income, it's not just from your employment income, they're not required to put in a tax return. And if you think about it, given that the average wage in the UK is around about the £26,000 or £27,000 mark, the bulk of employees, of people who work in the UK, do not put in an annual tax return. It often comes as a big surprise to a lot of people. You may or may not have heard of, so we don't have payroll tax on payroll. The employee is responsible for paying the PAYE, the pay as you earn tax. But then there is also what we call national insurance, which is levied which is effectively a social security levy, if you like. In order to qualify for the state pension here in the UK, you need to have paid national insurance, I think, for something like 33 years in order to get access to the full state pension. But both the employer and the employee pay national insurance. The national insurance is calculated on the individual's salary, and employees, and these rates are quite high, the employee pays 13.25%, and if they're a high earner, then they'll pay an extra 3.25%, and the employer pays 15.05%. Now, it's important to note that these rates may well change in a budget that is due to be delivered following the appointment of our new Prime Minister. But at the moment, just running those figures by you again, the employer pays national insurance at the rate of 15.05%, and the employee pays on the whole 13.25%, but an extra 3.25% if they're a high earner. The final point I want to make before moving off employment is in relation to insurance. And I know we've spoken about different employee benefits. I'm not talking about health insurance. The one point that you need to remember from all of this is that it is mandatory in the UK to have employers' liability insurance. So you can't employ someone in the UK by law, you are supposed to have employers' liability insurance in place before you employ someone. Interestingly, like most insurances in the UK, they're not horrendously expensive, and it is not a huge overhead to put in place an employer liability insurance policy. So that brings me to the end of my section on employment law. What I'm now going to look at is some matters in relation to intellectual property. There are four things I want to cover off in this section, and I'm going to start with the sort of the two most common ones. The first of those relates to company names and how you name a company here in the UK, and then the second one relates to trademarks. So I will cover off some more detail about territorial protection and patents at the very end. But the important thing to remember is that every registered company in the UK needs a registered name. If the company is going to be incorporated as a company limited by shares, then the company name will end with the words limited or the letters LTD. The word limited or LTD is a part of the legal name of the actual company. So important to remember that when you are actually referring to your company, particularly in legal documents, that you include the word limited or LTD. The really important thing to remember about company names is that it can't be the same or too similar or offensive. So it can't be the same or too similar to an existing company name, and it cannot be offensive. Now, what we often find is that when you go to sort of choose a company name in the UK, you will already have your trading or your company name in the US, and kind of one of the natural assumptions is, well, I can just incorporate my UK subsidiary of my US company by using the same name. That might be the case on the whole, and you might just modify the US name by sort of putting UK in brackets after that. The one thing you need to be really careful about is that your company name in the US is not trademarked, i.e. there isn't a trademark, which is different to a company name, but there isn't a registered trademark in the UK that is the same or similar to your company name. Because if it was, you may well have to change your company name in the UK. Now, to make things a little bit easier, the Registrar of Companies here does have an online name checker. So what we always recommend to people before they're looking at moving into the UK once you sort of start to think about the name that you might use for the UK company, is just to run it through the name checker. It's available on the gov.uk website. So if you just go to gov.uk and type in name checker, it will return a company's house name checker, and you can just type in the name that you're planning on using for your UK entity, and it will tell you whether the name is one that is likely to be registered. Now, what the name checker doesn't check is the trademark. So whilst the name might be available, we also recommend that you go, or you have somebody check to see whether there are any trademarks that are registered that are similar or the same as your company name, because it's pretty common if you try and register a company name here in the UK and there is a registered trademark, that the owner of the UK registered trademark will likely write to you and ask you to stop using the name under the threat of trademark infringement. So always, key point here is think about a company name, check to see if it's available, but also check to make sure it's not likely to infringe a trademark. Often we're asked the question about whether you can have a separate trading name to your registered company name. And the answer to that question is a simple yes. So a trading name, so you could have, I could be registered as Simon Walsh Limited, trading as John Enterprises or something like that. So you can have a trading name that is different to your company name, but there are a few little restrictions. So, for example, you can't have a trading name that includes some of the protected suffixes to names such as limited or PLC for a publicly listed company, or limited, or that type of thing. And of course, a trading name is also subject to the same tests around whether or not a name is offensive. So please bear in mind, registered name is your registered name. You may choose to use it as your trading name, but you don't have to. You could have an unregistered trading name. But once again, what you want to ensure is that neither your company registered name or your trading name is likely to infringe anyone's copyright. We're often asked about what are the minimum requirements, like where do I need to put my company name? So by law, your registered name must appear on your website. It must appear in emails, letters if you're still writing letters, and any promotional material or any form of company stationery. So there are often, for companies that are setting up in the UK, particularly if they're incorporating a wholly owned subsidiary, they'll forget that they need to modify their global website to include details of their UK registered name. But please do bear in mind that it is a requirement to have your company name on your website. So I've spoken a little bit about trademarks, but just wanted to touch on this a little bit more, because trademarks are an incredibly valuable form of intellectual property asset. And as you build up history in your trademark, you're building up value in the trademark. And we always recommend to our clients and any company setting up in the US, if you don't have a trademark registered in the UK, then we strongly recommend that you look at going through the process of registering the trademark if the trademark can be registered. And the really important point to remember is that just because you have a trademark registered in the US, unless you have also gone to the effort at the time of registering the trademark in the UK and the European Union, it doesn't, just because a trademark is registered in the US, it doesn't automatically give you trademark protection in the UK. If you want to protect your trademark in the UK and it's not already registered here, then the only way you can protect that is to actually go through the process of registering the trademark. Now, there's a whole bunch of rules around trademarks and what can and can't be registered, but there are a lot of similarities. Those rules are very much sort of global. I mean, most of the intellectual property offices around the world have tried to be as uniform as possible. Clearly there are some nuances, but on the whole, the rules are quite global. But the thing that often people overlook is they think, well, I've got a trademark in the US, so therefore it must be protected in the UK. That's not necessarily the case. So we'd suggest that if your brand and your trademark is very, very important to you, which we expect it is, then please ensure that you make the appropriate inquiries to go about registering trademarks. The process of registering a trademark in the UK is reasonably straightforward, assuming that the trademark can be registered. There is always a 3-month opposition period. So if the trademark examiner looks at your trademark and it meets the criteria to be published, then they will pass what they call the examination phase, and then they're required to publish it for a period of 3 months to give anyone who has a similar trademark the opportunity to oppose that trademark. Now, it's quite interesting. Trademark opposition is very, very common, and a lot of intellectual property lawyers clearly spend a lot of time defending and advising their clients on how to deal with conflicting trademarks. One of the interesting things that we're finding is that on the whole, most businesses don't like to litigate. And so if you find that there is a conflict between the trademark that you're trying to register and an existing mark and an existing trademark, chances are you might be able to find some common ground in some of these subclasses where you can agree that you will not use your trademark in kind of certain subclasses and that other party won't use their trademark in certain subclasses. So we always recommend that you sort of take if you do happen to come across, once you've got it, let's say you've got a trademark registered in the UK and then you come across somebody who you think might be in danger of infringing your trademark and they're going through that registration process, we always recommend to try to sort of come to an agreement about how both parties can use the mark, and it might require just a simple, subtle adjustment. But important to remember that litigation is not always the answer. We're often asked about the cost to register a trademark here in the UK. At the moment, it's very, very inexpensive. It's £170. That's not to say that you probably want to engage an intellectual property or a trademark lawyer just to help you work out which subclasses you really need to be registered in and that type of thing. But the actual fees levied by the intellectual property officer are very, very reasonable. One thing that I just wanted to say about territorial protection is that remember that the UK is no longer part of the European Union. So if you wanted to protect a trademark in the UK as well as the European Union, and it's not already registered in either of those territories, then you will need to register in the UK and you will also need to register in Europe. But most good intellectual property attorneys will be able to provide that guidance to you. And then finally, the one thing I wanted to say is that we also are able to register patents in the UK. There is often a question mark as to whether software is patentable. And I guess the simplest way of looking at that is on the basis that if the software does nothing unique, then it's probably not going to be eligible for a patent. But if it is unique and innovative, then it may well be able to be registered as a patent. That's all I was going to say about intellectual property.